I hope you're full of energy for this podcast that focuses on the World Trade Organization. Let's start by having a look at how the World Trade Organization came into existence. The World Trade Organization does not depend directly from the United Nations, but it can be categorized as a related organization. Compared to other international organizations, the World Trade Organization is rather young. It was born in 1994. However, its historical roots go back a little bit further in time. The WTO was born out of the GATT, the General Agreement on Tariffs and Trade, the free trade system established after the end of World War II. The WTO continued and expanded the basic ideas of the GATT. And this free trade system seems to have been rather successful so far. As you can see on this chart, world trade has been growing significantly faster than the world GDP, the world economy as a whole, since the end of World War II. Today, the WTO is headquartered in this building in Geneva. Its head is the Director General. It's a pretty big organization employing about 600 people. Its main tasks are to implement, administer and operate the WTO regulations and to provide a forum for negotiations and for settling disputes. The activities of the WTO center around the WTO regulations. How are those regulations structured? Top of the list is the treaty under which all other WTO regulations are placed, the agreement establishing the World Trade Organization. It's kind of an umbrella. However, it's a very short agreement containing only a few articles. In fact, the whole substance is in the annexes. Annex 1A contains multilateral agreements on trade in goods, and its centerpiece is the GATT that, as we have seen, dates back to 1947 and was simply integrated into the WTO regulations in 1994. Annex 1B contains the General Agreement on Trade in Services, the GATS. Annex 1C features the Agreement on Trade-related aspects of intellectual property rights, the TRIPS Agreement. And Annex 2 contains the Understanding on Rules and Procedures Governing the Settlement of Disputes, the so-called DSU, Dispute Settlement Understanding. All of this adds up to an extensive and very complex body of detailed rules on international trade with hundreds of articles spread over 4 core elements. The GATT focusing on trade in goods, the GATS focusing on trade in services, the TRIPS focusing on intellectual property and providing for minimum standards for the protection of intellectual property rights, and the DSU focusing on dispute settlement and establishing the dispute settlement body with its panels and appellate body in Geneva. It's not so easy to deal with the complexity of that huge body of detailed rules on international trade. But luckily, there are a few fundamental principles that run through the whole WTO regulations. The most important being the national treatment principle and the most favored nation principle. And we can find those principles in all parts of the substantive regulation in the GATT, in the GATS, and in the TRIPS. What does national treatment mean? How is it regulated? According to Article 3, the contracting parties recognize that internal taxes and other internal charges and laws, regulations and requirements affecting the internal sale, offering for sale, purchase, transportation, distribution or use of products, and internal quantitative regulations requiring the mixture, processing or use of products in specified amounts or proportions, should not be applied to imported or domestic products so as to afford protection to domestic production. Sounds fairly complicated, doesn't it? And paragraph 2 continues stating that the products of the territory of any contracting party imported into the territory of any other contracting party shall not be subject directly or indirectly to internal taxes or other internal charges of any kind in excess of those applied directly or indirectly to like domestic products. Moreover, no contracting party shall otherwise apply internal taxes or other internal charges to imported or domestic products in a manner contrary to the principles set forth in paragraph 1. Isn't that scary? It sounds really complicated. It sounds like somebody has worked really hard to make it difficult to understand. You might say typically legal. But let's try to sort it out. Let's try to find the key messages. The key message of paragraph 1 is that internal taxes and internal charges and so on should not be applied to imported or domestic products so as to afford protection to domestic production. And it's the last part of the phrase that is most central. It's all about preventing protectionist measures. The key message of paragraph 2 is that imported products shall not be subject to internal taxes or other internal charges in excess of those applied to like domestic products. So as you can see, it's all about avoiding discriminations of imported products compared to domestic products, to like domestic products. So in essence, it's about treating foreigners the same way as nationals, which is why the principle is called national treatment. The other fundamental principle that runs through the whole WTO regulations is the so-called most favored nation principle. Let's again take the article in the GATT on that principle. Article 1, paragraph 1 states that with respect to customs, duties and charges of any kind imposed on or in connection with importation or exportation or imposed on the international transfer of payments for imports or exports, and with respect to the method of levying such duties and charges, and with respect to all rules and formalities in connection with importation and exportation, any advantage, favor, privilege, or immunity granted by any contracting party to any product originating in or destined for any other country shall be accorded immediately and unconditionally to the like product originating in or destined for the territories of other contracting parties. Again, rather complicated, difficult to understand. What does it mean? Let's try to find out about the key messages. In order to find the key messages, we should concentrate on the second part of the provision. Any advantage, favor, and so on granted by any contracting party to any product originating in or destined for any other country shall be accorded immediately and unconditionally to the like product originating in or destined for the territories of all other contracting parties. Everything clear? Well, I agree. It's not obvious. But I think I should give you an example. This time I'm pulling out my whiteboard. I'd like to invite you to come with me on an expedition to an imaginary continent, and you can see already a piece of ocean on that map. And of course, that part of the world is regulated by the international law of the sea, but that's not what we are talking about today. In the meantime, you see on the map already a number of borders, and those borders are currently closed because of coronavirus, but they are still open for goods, so for international trade, and that is what is of interest for us today. We have also a number of states on the map, and some of those states are WTO member states. And this is true for state A, state C, state D, state E, state F, but not for B, G, and H. What follows is kind of a love story. Focusing now on states A and B, the governments of those states understand each other very well. They really like each other. They have close ties. They are best friends. It feels so close to B. The government of state A decides to grant trade privileges to enterprises based in state B. So state A opens up its market for enterprises of state B. But state A being a WTO member state, this leads to the question of whether there are any consequences with regard to the GATT Article 1, Paragraph 1. What do you think? Are there any obligations for State A based on that article, especially the second part? What do you think? Could there be any duties to be respected by the government of State A towards other WTO member states? Well, to that question, students usually come up with the following answer. Based on Article 1, Paragraph 1, State A should grant the same privileges to other WTO member states. That seems logical, doesn't it? But the government of State A is calling this into question. It says that State B is even not a WTO member state. It is outside WTO, and its relations with State A have absolutely nothing to do with WTO and GATT. So why should State A not be allowed to grant that State B outside WTO special privileges without being obliged to grant the same privileges to other states that belong to the WTO? What do you think? Is the position of the government of State A convincing or not? How would you argue based on Article 1, Paragraph 1 of the GATT? What's the crucial point in this provision? Take a minute or two to try to figure out, and I think you need to read that article quite carefully. As soon as you have made up your mind, go into the next podcast